Welcome, revelers. This is Off the Rails, Right versus Left, the podcast that we do because we think the left is evil. I'm Rob B.
And I'm Brad Lee.
And I'm Brian G.
And we are Off the Rails, Right versus Left. Again, we're doing this show because we think everybody needs to know that the left is evil.
Classic.
Oh, welcome, revelers. Oh, let me turn off the background music here. We don't need that going. We're back again. I'm continuing my my mission to give a little voice to the candidates that are lesser known and the races that are lesser known. Today, I'm going to be interviewing David Roberson. He is a candidate for Texas Supreme Court, place 6, if I got it right. And we'll verify that with him when he comes on, because I want to make sure that what's on the screen is exactly what you're looking for when you go and vote. Before I bring him on, I do have to make a disclosure for the purpose of ethics, because early voting did start this week, and this is actually the Supreme Court place 6 candidate that I voted for. So I just want to put that out there. I don't want to seem like I'm entirely impartial in the interview because I've already voted for him. But here we go. We're going to welcome him now. David Roberson. Welcome.
Howdy. How we doing?
Not too bad. Can you hear me okay?
Just fine.
All right. And you're clear as a bell, so that's wonderful. So I'm glad you were able to get the interview going because of the fact that we tried a few times and just couldn't get the time right.
Yeah.
So why don't you start off telling us a little bit about yourself and your background and how you think it helps you prepare for the Texas Supreme Court?
Yeah, absolutely. So I've been politically active my whole life, starting with local state Senate politics in Maryland when I was in high school. Then I was involved or attended CPAC in 2000 when W came through. So I was always kind of aware of that of politics, and being in the DC area was helpful with that as well. Also attended the inaugurations of Clinton and Bush in 2000. And then when I came to Texas for college and was a political science major. I had intended to go to law school since I was in high school or so, and started expanding my viewpoints and understanding a little bit more about how things worked. I am, total disclaimer, I am a recovering Democrat. I got swept up into the Obama years and was pretty, I was 24, I guess it was 24 and impressionable. But then after that, I moved up to New York for work, and I saw how far the left was really going to go. Right. And
right.
I couldn't go with them. And 2, I saw all kinds of awful things happening because of that directionality. Right. This was just not at all a part of something I wanted to be involved with. And so I kind of took a hiatus from being as involved as I had been previously. And then when I came back to Texas, I joined the Libertarian Party in 21 after reading up on some of the principles there. So that's kind of a philosophy perspective. As far as my experience, I've been practicing law for about 14 years. I'm licensed in the state of the Supreme Court of Texas, the Southern and Northern federal districts of the Fifth Circuit, U.S. Tax Court, and the Supreme Court of the United States. I haven't practiced in the Supreme Court, well, not yet, but what my experience has ranged from complex civil litigation to writing appeals for criminal defendants who we believe were wrongly accused and wrongly convicted, as well as pursuing federal lawsuits against intellectual property infringement, collections work that I did both on the defense and the collection side, the plaintiff side. And then ultimately, lately, it's been cases in tax court where I defend small to mid-sized businesses against the IRS and against their encroachments on taxation and disallowance of credits that the taxpayers are properly entitled to. So I think all of that is kind of it's a circumspect approach to law. It's not necessarily exhaustive as nobody can be, but it does cover several important areas. And I think that with that understanding of those areas, you can then utilize not only the resources of the court, and including clerks, but also any good judge depends on the officers of his court, the attorneys that are presenting either side to add information, to cite case law, to really illuminate the issue. And so with an understanding of those operations and an understanding of how the law works, you can utilize those resources and be ready to give a decision that's appropriate.
Okay. And so as far as your judicial philosophy, because now you're a practicing lawyer.
Mm-hmm.
So if you're going to be taking the judicial approach, how would you interpret the Texas Constitution? Are you more of a textualist, or do you believe this living document approach that the meaning can change over time?
Yeah, good question. No, my specialty or my focus in law school and even in my job is contract work, contract law, meaning, and there's a determination there where you look at just the four sides of the contract. You don't look necessarily at what we call probate evidence, right? Which is amorphous, which is subjective. And so to answer your question more directly, I would consider myself a strong textualist, right? I mean, I think the original, like, if you look at the text in its original form, there may be some base, so some concern for, does it still apply? What was legislative intent? And of course, as we know from as I know from my time working as a legislative liaison to the Capitol here, legislation can be for various reasons, and it gets through sometimes on technicalities, sometimes just because the court or not the court, who was there that day to vote or not vote, and or who put it through committee. So I think legislative intent is a very amorphous thing to utilize. So if you look at the plain text, what the words mean to the average person, or even the informed person, I think that's the safest route. And honestly, like, as far as coming from a perspective, I mean, I'm 40, right? I'm younger than any of the other candidates. I'm younger than most people that run for this position.
You're younger than me.
There you go. But I think that if you bring, your understanding of the world and how it works towards, and then read the text in that sense, you do sort of bring in some living part of the world, but you must be controlled by the text.
Okay. And to me, I'm fine with that. I do want to back up a little bit. In the first question I asked you, you mentioned wrongful convictions, and I actually just read an interesting article, and I only came across it because the person in the case happened to have the same last name as you.
He's my fourth cousin, actually.
Oh, is it? Okay.
Yeah.
So it's regarding the junk science law in Texas, and I just kind of wanted your take on the fact that it's been law for years and nobody has been retried under the junk science law, and that seems kind of. I get we've got backed up courts, but if we potentially have people wrongfully convicted in prison, that seems to be a problem.
It's a huge problem. I worked with the Innocence Project in law school, and then afterwards, where they actually go back and through called cold case, not cold cases, but cases where the person's on death row, subject to capital punishment, and go back, and a lot of that was DNA evidence when that first became popular or became an option, right? And as far as the junk science rule, I mean, those laws are pushed through, or not pushed through, but they're drafted and advocated and established for very compelling reasons. Case in point, Robert Roberson's case that's going through right now. Now, the fact that those tools are there and they are not being utilized is a failure, I think, of the legal community itself to really bring a passion and we are be aware of the laws that are available to prevent the government's overreach into private citizens' lives and to end private citizens' lives, right? And unfortunately, it's not a lucrative job. It'd be something that has to be a passion project. It has to be something that you're working towards. Personally, I think that there should be more provision on a state level for public defenders to be able to have the time and the effort and the finances to really involve themselves in these sorts of cases, knowing and be educated on the rules and the levers that can be applied. So I think the junk science rule is great. I think it's been underutilized, and we'll see how this headlining case affects it.
Okay, so now I do want to ask you again. I sent you kind of a guideline what I was going to ask, and for legal reasoning, I kind of want to ask about a specific situation, and that's asset forfeiture.
Okay.
Because I understand the purpose of the law. It's to try and, get assets away from criminals. But to me, it seems that it's 100% unconstitutional, both to the Texas Constitution and the U.S. Constitution, because you are, in fact, assessing a penalty on somebody that has not been convicted of a crime and placing the burden of proof of innocence on them, which is completely contrary to our justice system.
Mm-hmm. Yeah, it's an interesting question. And interestingly enough, I actually interned at the Harris County DA's office in the CIF division when I was a first-year law student. And working there or interning there, it was a free or an unpaid internship, is what turned me against and away from my intended goal of being a prosecutor. Right. And when I first came to law school, what is that, 15, 18 years ago now? And so to your point, when it comes to civil asset forfeiture, there's two cases going concurrently. There's the case of the state versus Mr. Smith. And then ironically, there's the case of the state versus $20,000 and a black SUV. Right. That's the style of the case, actually. Right. Because they're suing the assets and trying to attach criminal liability to these non-sentient assets for the purposes of acquiring them. Right. Now, the thing that really turned me off about this was that anytime somebody had had an attorney representing them, our cases got thrown out. Unless there was a kilo of some substance, some narcotic in the car on
but in that scenario it would lead to a conviction. I'm specifically concerned about the fact that I think it's like 70% of asset forfeitures the state or the jurisdiction maintains control of the assets with no conviction, and probably like 30% of the time no charges ever filed.
Yep. No, I agree with you completely. It's unconstitutional, it's inappropriate, and it's a lever it's something that's it was put into the government or put into the law in order to acquire those resources and those funds, and the money goes right back to either the DA or the sheriff's department, depending on if it's an auction or otherwise. And it incentivizes the government to inappropriately apply the law without any sort of accountability.
Yeah. I can't remember the town, but I was looking at one small town, and it's a great example. You go and look at their municipal budget, and their tax budget is like 500,000, but their municipal budget is like 1.6 million. And all the rest of that, they're right next to a freeway. So all the rest of that budget comes from the freeway, giving tickets and seizing assets.
Yeah. Road pirates.
Yeah. And like, I mean, that's to me, it's kind of a clear constitutional violation. So I just wanted to get your perspective on that. Now you are a libertarian, right?
I am the secretary of the Travis County Libertarian Party. I was in DC for the convention. I was on he's now the VP, but the Mike Termott campaign. And I voted Libertarian down the ticket, early voting. So yeah, absolutely.
I voted Libertarian down ballot all but one race.
Fair enough.
So now as far as practical application, like courts tend to drag stuff out at all levels. And to me, that's a big concern. And I think it adds to the ridiculous caseload that these cases get drug out. And I'm kind of not for the government ever getting a continuance because they have the obligation to present the case in a timely manner, and they're not afforded time to continue building their case. They should have their case ready before they make charges. So what would your approach to be dealing with caseload and ensuring things move along? And I know you're sitting on a panel at the Supreme Court, but
Right. It's a little bit different than a district court, but and so with the Supreme Court, obviously there's the scheduling concerns, whether or not it's going to be the full panel, or if it's going to be 3 that for a sub issue or something along those lines. But I agree with you completely. The government unless the prosecutor is dead or something, I think that you don't give the government continuance at all. Their duty is to have a reasonable suspicion, have evidence, and so on and so forth before charges are made. If they have to build their case for more than 30 days, let's say, there's something that means there's something up, right? If it takes more than 30 days, it should be maybe it's a federal case or a RICO case or something. But those kind of charges don't get filed until they have everything in order anyway, right?
Well, and then my other issue with that is, the way the legal process is supposed to work is you take a crime, you invest the crime, you arrest the suspect, you charge him, you take him to court.
Mm-hmm.
But they seem to be using it as they charge the person and then they investigate the person and find everything they can possibly find that they do wrong, so they can just try to throw the book at them and try and make something sick.
Mm-hmm.
And that also seems kind of antithetical to the way the justice system is supposed to work.
Yeah, no, absolutely. And that's exact. I agree with you completely. It's also the same exact way the IRS works when they audit someone. They don't have to tell you which, and I've defended probably 50 or 60 audits over the course of the past 10 years. And what they do is they come and they ask for all this stuff and they comb through it. They try to find anything that'll stick and they try to throw it at you, and it just doesn't, it's an excess use of power. Personally, I mean, it's an overreach of the executive branch's power. They've authorized these 3-letter agencies to just go out and do whatever they damn well please. So yeah,
for sure. And then now there is a lot of talk about ethics. We even have like our judicial code of conduct in Texas. A lot of it is centered around the Supreme Court and supposed favors and whatnot. Now, what is there a term for the Texas Supreme Court, or is that
not that I'm familiar with? As far as there's the
like the term limits, any of that, because I don't know that much about the office other than the functionality.
Yeah, there's no term limits. You're elected for 6 years at a time, and it's statewide. The place 6 doesn't refer to a region. It literally refers to
the sixth spot
on the bench, right? So there is no term limits. I don't believe there's not a mandatory retirement age either, unless I'm mistaken. But yeah, so of course, as you may know or may not know, the function of the Texas Supreme Court is specifically civil, right? We have the Court of Criminal Appeals. Specifically for criminal. So
and I couldn't get a single candidate from the Court of Appeals to actually come talk to me.
Oh well,
so
I'm sorry.
Yeah, I'm more trying to get a feel for your reasoning. So
as to term limits?
Well, no, just like the reasoning as far as how the law goes. So even though some of it applies to criminal, the Supreme Court applying to civil. And it does somewhat, I think, kind of bear upon even civil cases, because you see a lot of times civil litigation that follows criminal matters where the person is found not guilty and then sued and get a judgment for something that they were already found not guilty for. And that seems to me it's like a workaround, especially if the state or the city or the municipality ends up being the plaintiff in the case. Then it to me it ends up being a violation of double jeopardy.
I hear you on that. It's not so much double jeopardy specifically refers to.
No, I understand.
Okay, all right. But I do think that, due to the difference in standards of proof, more, beyond a shadow of a doubt versus more likely than not in the civil, or, beyond a reasonable doubt and so on, you can use it off the different phrases to describe the standard of proof. but the taint that attaches to an individual when there's a criminal proceeding of any kind, and that, well, maybe the jury maybe got on a technicality, maybe the judge did a jury notwithstanding the verdict, or maybe the jury was tainted, or all these questions that that are fodder for speculation in like news media or otherwise, provide a severe disadvantage and to a civil case, to a civil issue. So I agree with that.
Well, okay. So I'll do a very highly publicized example. Okay.
Sure.
And I'm not asking you to make judgment one way or the other as far as the case, but you take the O.J. Simpson case where he was acquitted, and then he got wrecked in a civil wrongful death suit. But if he had been responsible for wrongful death, he should have at least been convicted of manslaughter.
Mm-hmm.
So you're literally attaching a penalty to a person for something that they were not convicted of doing. And I know that more likely than not having happened, to me, it seems to be flawed, because then you don't actually have to prove something has happened, and somebody's penalized for it. And so if you're going into the Supreme Court, and this is where like case law comes in, because then a lot of times like people can be just like straight ran through a legal system, and then if they do finally get out and then they try and take civil action against the jurisdiction, then it's still going to end up in front of you for the same kind of violations. And then I also take issue with in these civil cases, you end up with the same parties that were, if the person was innocent, were persecuting them, are now colluding with the civil lawsuit against them.
Mm-hmm.
You see what I'm saying? So it just, to me it just like stinks of, and I guess you could even say like all the stuff that's gone on with Trump can even like bear that color. They don't like him, so they're going to come at him every which way, and whether it's civilly or criminally, that's not supposed to happen.
No, I agree with you, and I think that in those situations, especially with the state being the actor in a prosecution, and now with the state being the arbiter in the civil case, the state being the arbiter of what is and what isn't, that anything that is presented evidentiarily or otherwise needs to be either excluded under motions in limine, for example, or interpreted. The concept is called contra preferentum. Whoever's the drafter of the deal, or the promoter or the persecutor in this case, anything that they say or do or have should be interpreted against them, right? Mm-hmm. And limited in its scope against the person being pursued.
Yeah, and in civil cases, the evidentiary procedures are much more lax, and what's allowable is a lot more lax, which I find questionable too, because evidence is evidence. It is or it isn't, and there shouldn't be a discrepancy between what's allowed in a criminal case and what's allowed in a civil case. So, I mean that, and that's to me. And like, if you're on the Supreme Court, you may have to make judgments about that. Like, why were they even looking at this?
And I think when it comes down to it, the where I would lean is if this is, been in a case previously, there needs to be very, very good reasoning for it to be brought in this situation again. Kind of balancing that concern you mentioned with the idea of double jeopardy being involved in, at least in a conceptual form.
Yeah, well, and I understand it doesn't technically apply double jeopardy, although if the jurisdiction that prosecuted the person is then the one that seeks civil recourse against them, I think that is double jeopardy, because just changing which way you're going after him, you're still going after him after you already lost. Yeah. But on the flip side, if you're then colluding with other parties to still go after the person after you already lost. And that's the particular concern of mine, because now you have, again, the state is on two parts of the occasion there. If you follow what I'm saying, like
it's if it
the
was
case is the plaintiff and the judge.
Yeah, if it was a private individual doing this, it would be a conflict of interest.
Exactly.
Right?
So, and that's my concern, because a lot of cases go through the civil courts that work exactly like that, where there's a jurisdiction that went after the person, then colluding with a civil litigation. And to me, that's ethically like completely inappropriate.
Yeah, I hear what you're saying. I think I would agree with that as a guiding principle, if you will. And so I think that if a case that had those accoutrement or that background, I think it's important for a judge not to view any particular case in a vacuum, right? There needs to be concern as to who is involved, how is involved, who's bringing it, and why, and then ultimately the effect it's going to have on people. Now, obviously, you can't look at, you're bound to precedent, right? In a lot of ways, you're bound to precedent in case law, but I think that some of the other stuff is persuasive in terms of, and I think those would be points where I personally would ask questions of the parties, and hard questions, right? Just to get them to understand where I'm coming from and see if there's arguments that they can do to sway me one way or the other. With the tenets of the law and precedents being, underpinning the whole situation.
Yeah. Well, and I mean, I think sometimes judges have a tendency to look at precedents, say, okay, that's the precedents, but they don't look at the underlying precedents, and that's how you end up getting like case law overturned. So I certainly hope if you're on the Supreme Court, you're going to be digging beyond just the prima facie viewing of the precedents, but actually the underlining and underpinning reasoning behind it.
Yeah, and even in precedential cases, there will be dissents, there will be clarifications, and as you shepherdize through all the case law, the line of cases that's associated, and this is what I mean by being circumspect. You have to look at all of that and see maybe the facts line up more with the dissent in the particular case that's going on, even though the one side has quoted this case in their favor and the other side has quoted it in their favor. Or cited it. Excuse me. There's so much more, as you say, beyond the prima facie stuff.
Yeah, and then always the attempts a lot of times in civil litigation to try and, I don't want to say manipulate, but angle things in a way that you use the law in ways that it wasn't intended to, and then try and back up their support with precedent that's not actually indicated in the cases.
Or they pull a line or a phrase out of the case, and it sounds real good for them, and then you realize it was the opinion of either the dissent, or it was, and they were drawing a clarification between the two positions. So you have to, like I said, be judicial in your review.
Yeah, and a great example of that for any of the viewers that think the legal process is interesting is actually like listening to the hearings for the appeals in New York, and the way they take the precedent and then they tear it apart as far as what she's putting forward and what the case has actually entailed, because like on its face it looked like, okay, well, that precedent fails, but in the precedent it was talking about an uninformed investor versus a sophisticated investor, and both of these in this case is sophisticated investors all the way around. And then cherry picking like facts. Oh, this affects that fact, but in fact, in this case, even though there's a differential, it wouldn't have changed the outcome of the decision if it had been X versus X. So that's why it concerns me, because I've read a couple rulings out of the Texas Supreme Court where they accept precedents being submitted that had nothing to do with the case that they were reviewing. So that's why I wanted to ask.
Yeah, when he interrupted her two words in, I was just like, oh, here we go.
I as soon as that happened, I was just like kind of like moderately listening while I was like cooking, and I like stopped cooking, sat down, and like listened to the whole rest of the proceedings. So that was great. Now I kind of mentioned the Texas Code of Judicial Conduct, and it does have the reporting. It's a lot to go through, and I mean this is a huge problem with our legal system, that they make everything way more complicated than it needs to be.
Mm.
Like, I think, and in reading through this, like, I mean, I see judges, the requirement for reporting unethical behavior, whether it be for other judges or for, but I don't see what the mechanism is in the event that there's malfeasance by the judiciary to address that. Like, being it's an elected office, does the person have to then be recalled? Can they be dismissed by the governor, etc.?
Mm-hmm.
And I actually have another direction I'm going to go off of this.
So every lawyer has to take the MPE, the multi-professional ethics exam, and my professor for that class said, "Don't take money you haven't earned. Keep track of the money you spend, and rat on your friends." Those are the three things to take away from it as far as principles are concerned. And it's sad to say that that's something that's necessary to have in my profession or in the judiciary. When it comes to it, it is, as you say, pretty murky as to what recourse there is for malfeasance, because it's a lot of self-reporting or colleagues reporting on each other, and that's a hard thing to do. It's easy to stand up to your enemies. It's harder to stand up to your friends, right?
Yeah, and then once that report is made, then what happens?
To be honest with you, I don't know the answer to that question. I'm sticking to the I'm not going to mess up line of things.
Okay. Well, I'm glad you're not going to. I specifically asked because I perused through the whole actual Texas Code of Judicial Conduct. I even went back and read through 253.1612 of the Texas election codes that's referenced in it. Like, I went everywhere I could to look at it, and like, I don't see the recourse in the event of integrity. And now the reason that I asked that is, I'm not going to name names, but there's an awful lot of public officials, we'll just put it as loosely as possible, gaining a lot more wealth than their paltry state level salaries afford them, and the hot dog stand that they put as their business doesn't explain it either. If you follow me. So and then you turn around and you see those same politicians playing chummy with people on the bench, and it's alarm bells all over the place when you see that. And then you go and look, and then you don't see any recourse, and the state level government doesn't seem to even attempt to make recourse unless they're trying to dump off responsibility for their own malfeasance.
I mean, it's corrupt all across the board. Once you get in, you have to stay in, and people do, even good people get corrupted in varying levels. I'm not saying, and I am of a distinct advantage that I don't have justice or judge in front of my name yet. But to give that perspective to something, I don't think there's enough, especially in the day and age in which we live. I don't think there is enough clear vehicles for censure or for reproach or for recall,
removal,
as you said, or impeachment, right? It has to be so egregious and unhidden and blatant that it rarely, if ever, happens, right?
And generally, people that manage to get elected to office, they're sophisticated enough that it's not blatant.
Right. And even if something were to happen, if something were to be done, I mean, who's gonna have the chutzpah to turn in the person sitting next to them on the Supreme Court, or somebody in another district that they've probably shook hands with, or donated to, or have been donated to by? And even if that person does, and they get up and they know Ken Paxton, well, you know what he's going to do.
Yeah. Well, and that's my point. And then the people investigating to it answer to the executive branch, that is where the source of the corruption is. So
can you imagine a judge from a criminal appeals court getting brought up to the Court of Criminal Appeals for criminal activity? Wouldn't happen.
Never going to happen. So well, I mean, since we're talking about the problems, what reforms, if any, do you think are necessary for the Texas judiciary to better serve its citizens? Because let me add a little more context to that, because it seems like there's a lot of people with no evidence of crimes or wrongdoing, suffering penalties, either like, I mean, I even have my things with Alex Jones, like in his case, you know what I mean? The people that there isn't evidence of wrongdoing or activities that are constitutionally protected being penalized. And on the flip side, people that are clearly breaking the law not being penalized. So what reforms do you think are necessary for the Texas judiciary so it's actually serving its citizens?
Yeah, I think for the judiciary as a whole, I think term limits is appropriate. Nothing, like you don't need to be ensconced in a judiciary a judgeship if you're doing that cycle keeps it people out from being entrenched. Like, I mean, I think Texas statewide there's been only Republicans for 33 years now. I think it's always been sort of a handing off of power, and that just leads to more corruption. And as far as transparency or accountability, I think that the judiciary needs to be they need to become, if you're going to be a public servant in a judicial capacity, I think you have to be fully transparent on the public record with everything that you're involved in, right? I think it should be like there should be on your judge page should be, hey, I'm so and so, I'm here. These are my financials.
Yeah. Well, and like the code that I reference is actually kind of a funny code because it actually allows collusion between two justices seeking seats on the bench. And I'm just like,
yep, it's not good.
That's ridiculous. Okay, so there's what, 7 seats on the Supreme Court, right? 9. Okay, so then you can have 5 people colluding together to try and get control of the Supreme Court. That sounds dirty pool to me. Not that it's happening, but it's possible. And yeah, so even that, like on its face, like they don't use the word collusion, but that's what joint campaigning would be, is colluding.
Yeah, I mean, and I think that there is there's also, I think, more you could do as a bar to even be able to run for a judicial position. For example, if there's ethics cases brought against you by former clients, are there how many times have you been appealed? I think that should be appealed and overturned. For example, let's say I was a judge in the 281st or something along those lines. Somewhere a district judge is what I'm trying to say. District judge, and let's say I'm just off the rails, no pun intended, off the rails with my decisions, and I get appealed and overturned 60% of the time. I am not performing as a good judge, right? And clearly, either I'm not smart as to the law,
but there's a caveat to that.
Yeah.
Are you not a good judge, or the appeals court's not a good court?
Yeah, no, that's another good counterpoint. But I guess for my
there should be transparency for the voter.
As for transparency for the voters, I think your record should be you should be required to file your record. If are there ethics complaints, was the state bar brought into bear, whether as an attorney or as a judge, right? I think that's another good thing. And if you have too many strikes, then I think there should be a qualification standard for you to be able to run. Right now, the only thing is you have to be practicing without.
I would never kick candidate. The record should be clear. The financials should be clear to the candidate or to the voter. I don't think there should be a disqualifying standard, though, because it's real easy to then collude above them to get somebody from seeking higher office.
I think it should be something that's taken under consideration.
Yeah. Definitely. I mean, transparency to the voter. I don't want the government acting to like restrict any candidate, but I do want transparency in the candidates. But at the same time, I also want limits. Okay, like, you're the candidate. I don't care who your spouse is, who your kids are. I don't care what their activities are, as long as they're not trying to influence you. You get what I'm saying?
No,
if you're running for the appeals court, and your wife is a lawyer that goes to the appeals court regularly, then that's probably something we need to know.
Mm-hmm.
You know what I
Yeah.
mean? But beyond that, and it's for political candidates and judicial candidates, both, like, they try and murky the waters with stuff that's not relevant.
Yeah, and I think that in that scenario you described, I think that's grounds for recusal. For example, I have a friend who's a judge in Harris County, and they are involved in advocacy challenges at the local law schools. Like, they teach mock trial and moot court, right? And then, of course, as the years go by, those moot court students end up in the courtroom, right? And that's something that my friend, they always indicate to the whole court on the record and to the opposing counsel that this is a former student of mine. Are you okay with that, or do you need me to recuse myself from this case? And that's even less. That's even more tenuous of a connection than, say, my wife or a spouse is a practicing attorney in the court. So I think,
or has some interest in the case, or.
Yeah. So I think that, and I think there's a little bit of a duty as someone who is a practitioner of the law to take that extra step to avoid what I would call even the appearance of evil, right? Unfortunately, that's a matter of personal ethics on an individual basis, and so I can say that I would do that, and I know that my friend does that, but we can't say that necessarily it means everybody would do that, right?
Yeah, well, see that, and that might be one of the few statistics that I might see as disqualifying. If you're sitting in a civil court for 20 years and you never recuse yourself, I think at some point there you're disqualifying yourself, because there's no way you went that long without a conflict.
Yeah, because there's no way in 20 years of getting reelected that you didn't meet somebody at a fundraiser, or go to a law firm's Christmas party or something.
Well, and all the courts are, for the most part, local. So yeah, so I just find it interesting. Yeah, I mean, that's really all I had. I mean, you're more in civil law, and that's a lot harder to speak to. And my biggest issues with civil litigation is the acceptance by Supreme Courts that are ultimately supposed to be protecting the rights of the citizens, allowing ultra lax evidentiary standards in whether or not they overturn a case. And I understand the reasoning for it, but yeah, I think it leads, if you don't have hard and fast evidence and stuff, I think it just leads to abuse and malfeasance, and it ends up being who can afford the better lawyer, not who actually did wrong.
Sure. Now, applying my libertarian philosophy to the civil courts, it's my position that any kind of codes or regulations or guidance that are informing that are being used to go against an individual, let's say, a company versus an individual, a large company versus an individual, or otherwise, I think there needs to be a lean or a presumption even towards the rights of the individual, right? And that's not necessarily to say it's going to overturn precedent or it's going to create a new type of test for any individual case. But my personal judicial philosophy would be interpreting these regulations, again, against the person who drafted them, against the state, and in favor of the citizen.
Exactly. And that, like, and ultimately that I think that's what judges lose sight of, and whatever causes the bias or the jadedness, as it were. But the judges are there to serve the people, and they tend to be jaded against the people, particularly in matters where the state is the plaintiff, or even when the state is the defendant, because they are part of that state apparatus.
Yeah, and I think that, again, going back to the issue of precedence versus persuasive, if you look at you have to work within the bounds of the law, right? The textual bounds of the law, and you have to work within the line of cases that are, controlling, because I'm not arrogant enough to say that I know better than the people before me, right? But at the same time, working within those four walls, so to speak, you should also be concerned with how is the phrasing of my decision going to affect this individual or the individuals, the citizenry of Texas? And secondly, how can I use my opinion to positively guide, which is the role of the court, is to guide uh, the legislator to what they need to do if they really want to accomplish this. Like if they really want to accomplish X, but the case that comes before me doesn't do that correctly, or the law that is the foundation of that case doesn't do that sufficiently, you can, in your opinion, say, this, draw contrasts, or even do a concurring opinion or a dissenting opinion that gives guidance to the legislature. Now, we have three branches of government for a reason: to balance powers, but also to stay in our lanes, right?
Yeah.
Stay in our lanes, but say, hey, Mr. Legislature or Mr. and Mrs. Legislators, you could write it this way.
Yeah, absolutely.
Right?
So, and then I want to, like, my kind of overarching like thing that like I would wish every judge would keep in the back of their mind as they're viewing any case would actually be something I pulled. I had a 20-year career in corporate retail management. And there was the saying that there's a 10-10-80 rule. And the 10-10-80 rule means 10% of people are ultimately honest and incorruptible. 10% of people are completely corrupt and will always vie for corruption. And the 80% in the middle are generally honest, but given the right circumstances, will tend towards corruption. Okay. And that's the reason that's so important, is has to be applied not just to the citizenry, but also to the state. Not just the plaintiffs, but also the defendants. You know what I mean? Or not just the defendants, but also the plaintiffs. Yeah, because again, it comes down to, like, a really good lawyer can make a really good sounding case, but yet the poor person with a bad lawyer will end up looking horrible in court, even through a jury of their peers.
That's absolutely right. I mean, it's one of the things that is our responsibility as advocates, is to be zealous advocates for our clients, and whether that and provide them with a fair trial. I mean, I have a friend who's well known in the criminal appellate fields, and he's defended some people accused of heinous things, but his job is to give them to advocate for them within the bounds of the law, and that the public, or that the jury and judge make a decision. So it requires a certain level of personal ethics, and it requires, again, a commitment to the causes you believe in within the bounds of the law. So it's an interesting situation to be in.
Okay. Well, hey, I appreciate you taking the time to talk with me here today. I don't want to keep you too long. I know your schedule's busy trying to run a campaign. You still have your law practice going on, so you got lots of work to do. So I don't want to keep you too long. I do want to thank you for having the conversation. I'm always happy to talk to libertarians because that's where my mindset is. Probably at some point after the election, I'm going to touch base with you again, because I do intend to run for office in 2026. Okay. So
I have resources happy to connect you with. This is my second race. So yeah, let's talk.
Yeah. So I am a libertarian, and my inability to reach anybody with the official Libertarian Party is kind of concerning.
Do you know what county are you in?
I'm in Houston County.
Okay. They just affiliated with us. I can get you. We'll talk more about this, but I can get you in contact with who you need to get in contact with. The national party is hard to get in touch with, but LP Texas.
I have the same problem with the state level parties. So.
Really? Okay. Yeah. Well, I was formerly on staff, so let's talk more, and we'll get you connected, and there's a lot of good people you can talk to. Definitely
appreciate that. Well, again, thank you guys. If you're out there, you're getting your early voting done. If you haven't already done it. Make sure that you look at the Texas Supreme Court, place number 6. And your name is John David Roberson, right?
Yeah, it's David Roberson. It's J. David Roberson on the ballot.
Okay.
I go by David. I'm named after both my grandfathers.
Okay. So was it your father or your grandfather that once served on the court? Or is that another family member? Because there was actually a John Roberson that was on the court.
That's not somebody that I know. I'd have to look him up. It's not
I
somebody that I have ever met or know of.
Okay,
I
so
don't-
I was just curious because there's actually John Roberson, and I know you got J. David Roberson, so that's what you guys look for when you go to vote. J. David Roberson. Again, thanks for the time. I appreciate it, and you have a great night. Good luck on your race. Wish you the best of luck.
Thanks, Rob. Appreciate the questions and the time. Have a good one.
You too. All right, guys. So that's gonna be it for tonight. It was the only thing that I had going on today. So tomorrow I will be back. I do have an interview starting at 12. I've got several interviews tomorrow, but we're starting off at 12 with Mary Fox, Texas Senate District 25. So we're going to talk to her and then just continuing on. I'm going to try and keep interviews coming in every day all the way up to the election. So if you haven't already voted, then you'll be able to get in and listen to the candidates. I'm also now I'm finally starting to get some time. I'm getting a little faster, so we're getting some clips out. So you can catch some of what the candidates see in a shorter time period if you don't have time to listen to the full interview. But you can, of course, the interviews are everywhere. We've got 9 different platforms, and then pretty much everywhere you find podcasts. You can just Google Off the Rails, Right versus Left, and you'll find the page and all the different interviews that we did on any of the podcast sites and most of the video streaming services. So thanks again. You guys have a great night. For us here at Off the Rails, Right versus Left, we wish you good luck.